Just to give a little bit more context about where I come from, so I am in the MinterEllisonRuddWatts Construction and Infrastructure Division. I focus on disputes, and so I tend to be involved when a project goes into distress, and more lately when a project is in distress due to a solvency risk or an issue. My focus today is on minimising insolvency risk and also mitigating the impact of it when it actually happens and looking out for warning signs. I was saying to Sean Golan, who is also a partner at MinterEllison and was with me on the way out here and will be speaking today, that I would say 70% of my workload over the last 2 months has been focused on injunction proceedings in the context of distressed or insolvency risk projects. So I think that's indicative of the market that we're in and what's happening out there. Also, from a context perspective, these stats are interesting. I'm not going to read them all out to you, they're there for you to see, but demonstrates a significant increase in insolvency events and that construction industry is taking up a decent portion of insolvencies at the moment. I'm going to cover off insolvency risks and mitigation measures from the outset of the project all the way through to when an insolvency event actually happens. But before I do, the best way to start with these things is to set some context and talk about some war stories. So I'll start there, and this also gives us something to sort of talk to as we work through the issues. So I've actually got 3. The main one is on the screen in front of you. A few years ago, we were instructed by a principal who was building an industrial factory. At the point that they came to us, the contractor that was building the factory had abandoned the site, and there were rumours that the contractor was about to announce that it was going into liquidation and that liquidators were going to be appointed. Now, whenever this happens, the key point to think about first is what does the party that has approached you actually want? So in this case, the principal who we were acting for had a very strong desire to complete the project and to complete it with the existing subcontractors. So our mandate was essentially to help them get to that point, but there were lots of issues that came up along the way, which you may well be familiar with if you either have been the contractor or a principal in a project like this. First of all, the instruction was very clear that the principal wanted to terminate the contract, and so we were asked to consider whether site abandonment would amount to a breach by the contractor allowing the principal to terminate. Our advice in that scenario was that it probably did, because it was very clear that the contractor was not coming back. It's not always clear when the site is abandoned. Sometimes they're relying on a perceived right to suspend or a contractual right to suspend, so it will depend on the facts of the case, but in this case it was very clear that without any reference to the contract, they'd packed up and left the site. So the reason that was important was because that gave our client the right to immediately terminate the contract, which exists alongside the current process set out in NZS 3910. And the reason our client wanted to follow what we call the essential breach process rather than the 10-day working timeframe process under 3910 is it wanted to get through this quickly and to engage with the subcontractors quickly. If you follow the NZS 3910 process, there is a process whereby if a contractor is actually insolvent or has announced a receivership liquidation, then there is a process whereby notice has to be provided allowing the liquidator or the receiver to announce whether or not they are going to be continuing with the project and how. Our client wanted to avoid that process, so before it went into liquidation, they terminated. Sure enough, the liquidation of the contractor was announced shortly afterwards. This didn't mean that our client could immediately engage with the subcontractors until the liquidator had, which I'm sure my other colleagues will talk to, disclaimed the underlying contracts. And the reason that was important is because if our client had gone immediately to the subcontractors and tried to engage them and essentially pay them, there was a risk, and a very clear one, that they would be interfering with an existing contractual relationship, which is a big no. There are things that you can do at the outset to avoid that risk, but in this case we didn't have those tools. So it was only once we were able to enter into negotiations with the liquidator and understand the lay of the land and those subcontracts were disclaimed that our client was able to enter into contracts directly with the subcontractors. There's also a risk there though in terms of the principal paying the subbies any amounts that they haven't been paid by the head contractor, or any amounts that they demand, because, as again my colleagues will talk to, there may be an argument that those funds should have been paid to the contractor and been part of the money available for creditors. So there's lots of things to be cautious of in this instance. In the end, what sort of got our client over the line was that they adopted a very transparent and open dialogue with the liquidator, which enabled the parties to move quickly to basically do what was necessary to get the project complete while the liquidator could deal with the liquidation of the contractor. Another story, so I've been working closely with a key contractor for about a year now, and been sort of overseeing their balance sheet. From 1 month to the next, the balance sheet went from being a very healthy balance sheet to a very dire balance sheet. And the reason for that was that this contractor had 3 significant contracts with one developer who had finance from a second-tier financier. One of those projects was the funding stopped, so that meant that the developer could not pay our client, and so the funding stopped there, so our client's cash flow stopped. Then another one fell down, and there was only one left. But because that pipeline made up a significant existing amount of our clients' ongoing balance sheet, that turned our balance sheet from being very healthy to very unhealthy very quickly. And I suppose the lesson there is just being very cautious about putting all your eggs in one basket, basically. And I think from both the principal's perspective and if you're a subcontractor engaging with contractors, being very clear on where the money is coming from and how viable the projects are when you're contracting with these people. And last but not least, and I know this is going to feature in a number of the sessions today, Mainzeal. So in 2013, I was acting on 2 significant cases concerning Mainzeal. In one of them, I was acting for a client that had brought a $50 million plus claim against Mainzeal, and on another, I was defending a claim brought by Mainzeal against our client on a significant project. In relation to the project the claim that I was pursuing on behalf of our client for over $50 million, when the financial records were interrogated, it turned out that Mainzeal had put a 0 risk on that claim. Now that's something to be mindful of when you're doing due diligence on subbies, or if you're a principal on your contractors, is what claims do they have against them, and what value have they put on those claims, and have they just ranked them all as 0 or significant claims as 0? Because certainly from the other side of the fence, the risk for Mainzeal was not anywhere near 0 on that particular claim. I'm interested to hear from my colleagues on that as well. Right, so with those sort of war stories in mind, what I'm going to be doing is talking you through measures you can take to mitigate insolvency risk and warning signs throughout the duration of a project. So when it starts and the parties are contracting with each other, to the actual delivery of the project, and then once an insolvency event happens. Now this slide, hopefully you'll all have the slide packs to walk away with. This slide really sums up the rest of this presentation into one diagram. I have to credit Travis Tomlinson, who is a partner in our front-end and project team within the division, who put this together, and I think it's a great way of consolidating essentially the key points that I'm going to be making over the next 10 minutes or so. Right, so at the start of a project, what should you be doing? Well, with reference to the war stories that I've just told you about, carry out comprehensive due diligence on contracting counterparties. And what does that actually mean? Look at their balance sheet. Even though the balance sheet on its face might demonstrate a healthy balance sheet, you need to have a look at where the existing projects are sitting. Are they sitting with only one main party? Who is financing those projects? Because even though you've got a new project, the viability of your counterparty does depend on essentially their current health in terms of financials and their pipeline. What I've learned over the last while as well is that even though from an accounting perspective the balance sheet might look healthy, you do have to interrogate it. So if, for example, there is, you're on the right side of the equity line, but the assets that have been counted towards that equity are not necessarily realisable if needed, you have to factor that into account. So, for example, if the balance sheet relies heavily on retentions that are being held upstream from a contractor, whilst those retentions are technically being held on trust, they are subject to that party meeting their contractual obligations and that being agreed by the other party unless you go to court. So including the retentions in your balance sheet from, and I'll defer to my friends over here, but from an accounting perspective I understand is acceptable, but when you're interrogating the balance sheet you do need to look at how much of the equity is coming from amounts that are not readily realisable or may never be realised. If there is a dispute, for example, over retentions, or if there are defects that aren't yet known about in works that the contractor is carrying out. Consider the pipeline of projects. Again, consider the viability of those projects, how much capital is behind them, who is the financer on those projects, and are they all with one person, one party? And what is the track record of the party that you're contracting with in terms of similar projects? Look at the current delivery pipeline, and I think what's also important that some of my clients have been scarred with is resourcing. So it's always good to see a healthy pipeline of work for your counterparty, but if it's so healthy that the resources are actually available for your own project, that's a warning sign. How much risk is the contractor carrying on its other projects? There's always a balance in terms of how much you can see, including whether you can see the other contracts, because there are often confidentiality clauses. But you will want to understand what procurement models they've entered into, whether it's build only, is it design build, is there an early contractor involvement in place, is that how they like to work? Level of investment in the business, who are the shareholders, and who does the other party tend to work with? If they're a subcontractor, do they tend to work with main contractors that have a good reputation and stable reputation in the market? And if they are a healthy main contractor, do they work with well-known principals and developers that can speak for them? Right. Also, when you are at the outset of the project, you need to consider the security package. I overheard a conversation just before we started on this earlier, and we are going to have a discussion about retentions as well. But bonding tends to be the favoured form of security. However, bonding capacity is not always favourable. So that tends to mean that parties end up with retentions, and we're going to be talking about that later. Parent company guarantees. So in the case that I'm involved with at the moment, the project is with a New Zealand contractor, but there is a parent company guarantee for their Australian parent. The solvency of the Australian parent is very sound, so there is decent security on that project. Another important point, and I made this in Wellington as well, is that if you are dealing with a contractor and you are wanting to you want to have confidence that they're going to be able to deliver this project and they're going to have good relationships with their subbies, you should be asking them questions about the terms of their contracts with their subbies. I tend to act for principals and subcontractors or consultants. Sometimes I act for contractors, but the most onerous contracts that I see are between the head contractors and the subbies. Some of them I can't actually believe a sound mind would have signed the document, but I know that they're commercial parties. Contracts which basically prevent any claims going upstream unless those claims are able to be made to the principal and paid. And I'm not averse to back-to-back clauses, and they are helpful, but you must be able to bring a claim irrespective under your own contract for any breaches, for example, that the contractor might commit. So that would be a big point, is that we should be interrogating head contractors on their terms with their subbies, because onerous terms often lead to terrible outcomes. And that's the same in terms of risk allocation upstream as well. It's all very well, once you've signed the dotted line, to think you've got yourself a fantastic deal, but it's only as good as the solvency of the parties and the ability of them to actually meet the risks that they've taken on. So a balanced view is always necessary. Right, so I've covered the main points on commencement. I do have to make sure that I get through the material, so please do refer to the slides to the extent I haven't covered what we're needing to. So once we've gone through the commencement and we're in the delivery phase, there are things that we can be doing to keep track on how the project's going, and also warning signs that we can look out for to anticipate a potential insolvency event. From a project delivery perspective, in terms of good practice, and I'm sure many of you have heard this before, either from me or some other lawyer, is don't put the contract in the bottom drawer. Make sure it's front of mind. Make sure the parties are diligently following the payment claim and payment schedule process. The more transparent and consistent payment claims and payment schedules are, the less likely there are going to be surprises in the long run. If you're a contractor and you are experiencing a number of variations from the principal, check your contract for the notice provisions. Are you claiming in accordance with the notice provisions? Are you claiming in time? A client that I was working with the other day had simply overlooked claiming for variations, even though everyone knew there was variations. But and we were facing an uphill battle in terms of actually being able to claim for them now, because there was what we call a condition precedent in the contract, which means that if you didn't claim within a certain amount of time, you were time barred and the claim was not able to be brought. So you need to look out for those. And these variations were significant, and when you're dealing with a contractor that's cash flow dependent and they're not able to claim for variations, that has a significant impact. In terms of warning signs of potential insolvency event, having just talked about claims, if you're a principal or you are a contractor and you are seeing a sudden increase in claims and potentially speculative claims and demands for claims to be made very, very quickly and within unreasonable timeframes, that can be a sign of things being amiss. Obviously, rumours on site, that's usually the best way that we find out about what's going on, that a contractor may not be paying their subbies, the subbies are walking off site. We've had one where the subbie walked off site and then went into liquidation. So you need to be, if you're a principal, it's important to be aware of those things. Again, you can't necessarily go directly to the subcontractors and enter into new arrangements, because you're interfering with contracts, but it's something to take up with your contractor. One other point that I should have made at the commencement that is very important once you get into an insolvency event is to make sure you have continuity deeds between principal and subcontractor. And so that means that if there is an insolvency event on the part of the head contractor, there's an ability for the principal to engage directly with the subcontractor. And the terms of that deed can be whatever the parties agree to, but I would suggest turning your mind to whether, if there is legitimate evidence of payments that should be made to subcontractors not being paid, or subcontractors walking, that the contractor is imminently facing liquidation, how can that be dealt with in this continuity deed? It's tricky, but worth turning your mind to. As I've said, ensuring strict compliance with the contract is key, and without what I would call taking an overly contractual approach, parties can always reserve their position and understand what should be being done under the contract while having conversations about how to get the project finished. And by that I mean, what we're facing on a current project is that the contract is very clear, both parties understand what it says, but they are needing to enter into, without prejudice, discussions to work through how they're going to manage their relationship to get the project finished and what concessions they might need to make under the contract. And that can all be done in parallel with making sure you're actually following the contract in the meantime. Letting the contract go or not following contractual terms just creates all sorts of problems down the track. Oh. Right, I think I'm rapidly getting to the end of my session. So turning now to the actual insolvency event itself, which is what we're going to talk more about from now on. Depending on where you sit in the construction matrix, so if you're a principal contractor or a subcontractor, you're going to be interested, either you're a contractor who is appointing a liquidator or receiver, or you are a principal who is interested in the appointment of the liquidator or receiver. you may be the person that has put the party into liquidation as well. So if there is any ability to control the appointment, then it's going to be important to make sure it's somebody that has got a good reputation and is known for essentially understanding the law and what they need to do. And is also known to have a level of pragmatism in terms of either dealing with what's happened and or getting the project complete. We talked about this in a session that we had at our firm a little while ago, that what we can sometimes see is, again, a very contractual and legal approach taken in the event of a liquidation or a receivership. But it's really important to get the parties around the table if you want the project finished, because simply sending nasty letters in this context isn't going to get the project done. So if you're a principal and you want your project finished, getting a line of communication with the liquidator or receiver will be really important. And if you're a subcontractor who is on a project where the contractor has gone into liquidation, you're going to want to be keeping an eye on who is going to be appointed as the liquidator or receiver or administrator, and you're going to be wanting to develop a line of communication with the principal through those channels or through any continuity deeds you have with the principal. And other important things, if you're the principal or if you're a contractor and the subby's gone under, immediately take steps to secure the site, the works and the site materials, make sure they're safe and protected, undertake an audit of all plant, equipment, materials and documents on site. If you're the principal, get security guards on site, and understand your contractual rights in relation to termination, payment, security, on and off site materials, subcontractors and insurance. Termination, that was something that I spoke to you about right at the beginning, that there are rights of termination that exist within your contract and at what we call statute or common law, but NZS 3910 is fairly well known in terms of the 10-day working day period for principals that are wanting to essentially terminate the contract because of an insolvency event and want to get on to secure the site. So that's clause 14. Also being able to enforce whatever agreements you have in place. So I'm dealing with a case at the moment where we act for the principal. It has a build-only contract with the contractor, but the contractor is required to procure materials and install them on site. Contractor had purchased the materials, and the subcontractor who was responsible for bringing those materials onto site decided to hold on to them because there was a dispute between the contractor and the subcontractor. So our client, being the principal, is wanting to open its facility but doesn't have these materials on site. So it's relying on an off-site materials agreement, pursuant to which, once it has paid the contractor, title passes for those goods. So technically those goods belong to our client, even though there's a dispute between the contractor and the subcontractor, which on its face seems unfair for the subby, because the subby is saying, well, I've got these legitimate claims against the head contractor and they haven't paid me, so I'm holding onto these to create leverage for myself. But unfortunately, they gave that leverage away right at the start when they signed the off-site agreement. So it's important to be aware of those things, and important if you're the principal to understand that those rights may exist under your off-site agreements. Look, there's a lot more to get through, including insurance and the like, but I'll turn to my colleagues and we'll be able to answer any questions at the end. Thank you.